Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study Case Law N0.40/2020/AL about regarding the recognition of the practical land use rights. The case law was by the Judicial Council of the Supreme People's Court on February 23, 2021 and published under Decision Number 42/QDCA on March 12, 2021 of the Supreme People's Court. Part 1 Source of the case law, Part 2 Overview of the content of the case law, Part 3 Content of the case, Part 4 Assessment of the court, Part 5 Rules. Part 1 Source of the case law. Cassation Decision No. 37/2019/DSGDT on June 28, 2019 of the Committee of Judges of Collegial People's Court in Hanoi on the civil case of property inheritance dispute in Thanh Hoa Province between the plaintiffs Mr. LUient C1, LUient C2, Ms. Lu TM and the defendants Mr. LUient D1, Ms. LUient T2. Persons with related interests and obligations are the People's Committee of B-Town and Ms. Lai Th. Part 2 Overview of the content of the case law. 1. Background of the case law. The parties transferred the practical land use rights without a written agreement. The parties have used the land for long and stable term and dispute-free, have registered, declared and been granted a land use right certificate for the transferred land. 2. Legal solution. In this case, the practical land use rights must be recognized and the parties have the right to use the transferred land. Keywords of the case law. 1. Transferring of practical land use rights. 2. Using land for a stable and long term. 3. Granting the land use right certificate. 4. Recognizing the transfer of practical land use rights. Part 3 Content of case law. Based on the petition dated February 18, 2014, and the process of resolving the case, the plaintiffs Mr. LUient C1, Mr. LUient C2 and Ms. Lu TM presented. When Mr. LUient got married to Nguyen TK, Mr. Yu had 3 stepchildren, with his dead wife, who are Mr. LUient T1, Mr. LUient D1 and Mr. LUient D2. Mr. Yu and Ms. K have 3 common children who are Mr. LUient C1, LUient C2 and Ms. Lu TM. In 1963, Mr. Yu and Ms. K left Q Commune, H District to reclaim a new economic zone in L Village, now in 5 Village. T Commune, B Town, Thanh Hoa Province, and brought with them 04 children, Mr. D2, Mr. C1, Mr. C2, and Ms. M. When preparing to move, they unloaded the kitchen to bring with and left the house with 05 rooms at Q Commune for Mr. T1 and Mr. D1 to own. Mr. Yu and Ms. K reclaimed land plot number 986 in 5 Village, T Commune, and built 05 houses to live in. Mr. D2 enlisted and died in 1972, unmarried. Mr. C1 and Mr. C2 enlisted. In 1989, Mr. C1 discharged from the Army. In 1992, Mr. C2 discharged from the Army. Mr. T1 got married to Ms. Lu C3. Mr. D1 got married to Ms. Nguyen T2. Because during the time living in Q Commune, Ms. C3 and Ms. T2 had a conflict, Ms. T2 went to S Town to stay with Mr. Yu, Ms. K, and Ms. M in 1983. In 1997, Yu died without a will. On October 14, 2003, Ms. K noticed that the members of her family had land conflicts, so she called Mr. C1, Mr. C2, Ms. M, Mr. T1 and Mr. D1 to the family meeting with the purpose of distributing the inheritance with land plot number 986 in Village 5. T Commune. The meeting was recorded by Mr. D1 with the purpose of distributing land use right. At the meeting, all of them defined the source and the boundary of the land plot, but could not agree on the distribution. Specifically, Ms. K, Mr. C1, Mr. C2 and Ms. M did not agree with Mr. D1's opinion which they would receive 10 m of road surface. In 2006, Ms. K died without a will. Members of the family have discussed distributing the parents' property, but the agreement couldn't be reached. Then Mr. C1, Mr. C2 and Ms. M asked the village authorities to mediate on August 22, 2008. On October 10, 2010, Mr. D1 admitted living in the disputed land from 1984 up to now. Mr. C1, Mr. C2, and Ms. M sue to request the court as follow: cancel the certificate of land use right. No. C364176 under the name of Ms. T2's household in Village 5, T Commune, declare that 116 square meters of land plot number 986 for their parents' church, the remaining was distributed. Regarding the works on land plot and nearly 20 m of road surface which Mr. D1 sold when Mr. U and Ms. K were still alive, the plaintiffs did not reclaim and request to distribute the inheritance. The defendants Mr. D1 and Ms. T2 presented. In 1982, Mr. D1 and Ms. T2 were granted a plot of 288, map sheet No. 299 in the cadastral map of Commune T. After that, they exchanged area of 2,112 square meters in the above land plot to get land plot number 986, the plot number 40 according to the 1997 map, of Mr. U and Mr. K. They supposed that the land plot number 986 was no longer owned by Mr. U and Ms. K, and now they have been granted a land use right certificate, requesting the competent authority to revoke the land plot No. 288 under the use right of Mr. U and Ms. K. The fact that Mr. C1 arbitrarily transferred that land to Mr. Trin Van T3 was illegal, because there was no discussion of family members including Mr. D1. The land plot number 288 of Mr. U and Ms. K, which was granted a land use right certificate in 1994, is inheritance. Mediation minutes which the plaintiff filed attached with the petition are not objective, not accordance to the law, because they has been granted a land use right certificate from 1994 to now for more than 20 years. There was no dispute before they were granted the land use right certificate. At the first instance civil judgment number 04/2016/DSST dated May 27, 2016, the People's Court of Bimsun Town decided. Cancel a part of decision number 71/QD/UBBS dated September 23, 1994 of B Townspeople's Committee on the Long-Term Stable Land Allocation and Land Use Right Certificate for Mrs. LUient T2's household. The People's Committee of Town B was obliged to revoke the Land Use Right Certificate No. C36476 under the name of Ms. LUient T2's household to carry out the procedures for reissuance of the Land Use Right Certificate in accordance with the law. Distributing the inheritance of Mr. LUient K to Mr. Levan C1, Mr. Levan C2 and Ms. LUTM, which was 538 square meters of land in 5 Village, T Commune, B Town. Specifically, each person was entitled to share the right of use of area 179.33 square meters with the value of 137,708,000 VND. Temporarily handing over the heritage of Mr. Levanyu including 1/2 land plot number 986 with an area of 538 square meters to Mr. D1 for continuing to manage and use until there was a decision of a competent state agency. In addition, the Court of First Instance also has other decisions, court fees, and the right to appeal. On June 8, 2016, Mr. D1 and Ms. T2 appealed the entire first instance judgment. At the appellate civil judgment number 85/2016/DSBT dated September 16, 2016, the People's Court of Thanh Hoa Province decided not accepting the appeal of Mr. Levan D1 and Ms. LUient T2. Upholding the first instance judgment number 04/2016/DSST dated May 27, 2014 of the People's Court of Bimsun Town. On December 30, 2016, and limited liability law firm, who protects the rights of Mr. D1 and Mr. D1, Ms. T2 have a request to review the appellate judgment under the cassation procedures. At the cassation hearing, the representative of the Superior People's Procuracy in Hanoi requests the Judicial Committee of the Superior People's Court in Hanoi to accept the appeal of the Chief Justice of the Superior People's Court in Hanoi. Part 4. Assessment of the Court. Mr. Levanyu and Ms. LUient K have 3 common children who are Mr. Levan C1, Levan C2 and Ms. LUTM. Mr. Yu has 3 separate children, with his wife dead, who are Mr. Lequang T1, Mr. Levan D1 and Mr. Lequang D2, died in 1972 without wife and children. In 1997, Mr. Yu died and in 2006, Mr. K died without a will. On February 18, 2014, Mr. C1, Mr. C2 and Ms. M filed a lawsuit requesting the court to cancel the Land Use Right Certificate No. C364176 dated September 23, 1994 under the name of Ms. T2's household in 5 Village, T Commune, Town, B Commune, Thanh Hoa Province, divide inheritance of land plot 986, map sheet 1, cadastral map of T commune, town, B commune, Thanh Hoa province, which is managed and used by Mr. D1 and Ms. T2. In the process of resolving the case, the litigants agreed that the origin of the disputed land was reclaimed by Mr. U and Ms. K. Mr. D1 and Ms. T2 declared that, in 1982, they moved from District H to B town to live with Mr. U, Mr. K. and Ms. M in the above land plot. In 1984, they were granted a land plot in the petrol zone, in Com Vang, by T People's Committee of Commune. Then they exchanged the granted land to Mr. U and Ms. K to get land plot 986, the plot number 40 according to the 1997 map, and they have been granted a land use right certificate. Thus the disputed land is not the heritage of Mr. U and Ms. K, is their private property. Ms. M and Mr. C1 unanimously declared, in 1984, at that time Mr. C1 and Mr. C2 were still serving in the army. Mr. C1's wife, who was taught in another locality, could not apply for land, as Mr. U's request, Ms. M is in the name of Mr. D1, made an application for land allocation for Mr. C1, but T People's Committee of Commune granted the land plot to Mr. D1, because Ms. T2 did not accept living in the new land and to avoid family conflicts. Mr. C1 built a house in the newly granted land and brought Mr. U, Ms. K, and Ms. M to live there. Therefore, although the newly granted land is under the name of Mr. U's household, it belongs to Mr. C1. The official dispatch number 910/UBNDTNMT dated July 28, 2014 of the People's Committee of Bimsun to purport as follows. According to the map 299 approved in 1985, the disputed land location belongs to parcel 986 with an area of 1,616 square meters of T-land without the owner land use right. According to the measurement map recognized in December 1997, the disputed land belongs to parcel 40. Map sheet number 17, area of 1,263 square meters, including 200 square meters of residential land and 1,063 square meters of garden land. The owner land use right is Mr. D1. According to the cadastral map of T commune approved in December 2011, the disputed land location belongs to the land plot 262. The map sheet number 56 on the area of 1,571 square meters, including 120 square meters of residential land and 451, 4m2 of land for cultivation of perennial trees. The owner land use right is Mr. D1. According to decision number 201QD/KTK dated July 14, 1989 of the General Department of Land Administration on promulgating regulations on granting certificates of land use rights, decision number 117/NN/UBTH dated January 21, 1993 of the People's Committee of Thanh Hoa Province on the allocation of long and stable land to farmers and report number 73/TT/UB of August 20, 1994 of the People's Committee of T Commune with the attached plan on the approval of the grant of a land use right certificate. The People's Committee of B Town issued the decision number 71/QD/UBBS dated September 23, 1994 on allocating land for a long and stable term and granting land use rights certificates to 716 farmer households of ex-cooperative, T commune, including households of Ms. T2. Ms. T2's household was granted a land use rights certificate on September 23, 1994. The total area of land is 3,409 square meters, including 200 square meters of residential land, 786 square meters of farmland in plot 986A, and the rest is land for agriculture production. According to report number 73/TT/UB dated August 20, 1994 of the People's Committee of T Commune, the People's Committee of T Commune submits to the Chairman of Town People's B Committee for approval on the allocation of land for a long and stable term and granting land use right certificates to 716 farming households in the commune which publicized their dossiers and granted land use right certificates. In decision number 71/QD/UBBS dated September 23, 1994, the People's Committee of B Town decided to allocate land for a long and stable term to 716 farming households of ex-cooperative, T commune. According to the above decision, Ms. T2's household is allocated an area of 3,409 square meters, of which 200 square meters of residential land, 876 square meters of agricultural land are all in plot 986A, the rest is paddy land in different plots. Her household has been granted land use right certificate on the same day. Household Mr. U is allocated an area of 1,776 square meters of land, including 200 square meters of residential land, 556 square meters of agricultural land are all in plot number 325, according to the testimony of the litigant to be plot 288, the rest is paddy land in different plots. Thus, the case files show that the allocation of land to farmers in T commune is implemented publicly according to the state policy. When the People's Committee of T commune and the People's Committee of B town implement the policy of allocating land and granting land use rights certificates to 716 farmer households of T commune, including householders Mr. U and households Mr. T2, both Mr. U and Ms. K are still alive but did not declare for the disputed land plot, only declared the land plot no. 325, according to the testimony of Mr. D1 and Ms. T2, the land plot number 325 was their land plot, then exchanged for Mr. U and Ms. K, and have been granted a land use right certificate for this land plot, and Ms. T2's household has been granted a land use right certificate for the plot 986A, the disputed plot 986. On the other hand, no one complained after Ms. T2's household was granted the certificate of land use right for the disputed land plot, until 2008, when Mr. U and Ms. K died that the dispute occurred between their children. Therefore, there is a basis to determine that Mr. U and Ms. K exchanged land for Ms. T2, Mr. D1. First instance court supposed that according to map 299 in 1985, Mr. K and Ms. U were the user of disputed land, so the disputed land was the legacy of Mr. U and Mr. U's inheritance has been divided. This is not correct. After the first instance trial, Mr. D1 and Ms. T2 appealed the entire verdict of the first instance. The appellate court has determined that land plot number 325 under the name of Mr. U was the private property of the spouse of Mr. C1, and the land plot number 986 under the name of Ms. T2 is the inheritance of Mr. U and Ms. K. Thus, the appellate court do not accept the appeal of Mr. D1 and Ms. T2 and uphold the decisions of the first instance court is a serious mistake that damages the legitimate rights and interests of Mr. D1 and Ms. T2. On proceedings, when resolving the case, the court of first instance and appeal did not send Mr. T1 and his two children to D1 and Ms. T2 participated in the proceedings as a related person with rights and obligations. This is flawed of the court of first instance and appeal. Part 5. Rules. Pursuant to Point A, Clause 1, Article 337, Article 342, Clause 3, Article 343, and Article 345 of the Civil Procedure Code. Accepting protests of the Chief Justice of the High People's Court in Hanoi. 1. Cancel the appellate civil judgment number 85/2016/DSBT dated September 16, 2016 of the People's Court of Thanh Hoa Province and cancel the first instance civil judgment number 04/2016/DSST dated May 27, 2016 of the People's Court of Bim Sun Town, Thanh Hoa Province for the case of inheritance dispute between plaintiffs Levan C1. Mr. Levan C2 and Ms. Lu TM and the defendants Mr. Levan D1, Ms. Nguyen T2 and other persons with related rights and obligations. 2. Hand over the case files to the People's Court of Bim Sun Town, Thanh Hoa Province for retrial according to law provisions. Thus, the case files show that the allocation of land to farmers in T commune is implemented publicly according to the state policy. When the People's Committee of T commune and the People's Committee of B town implement the policy of allocating land and granting land use rights certificates to 716 farmer households of T commune, including householders Mr. U and households Mr. T2, both Mr. U and Ms. K are still alive but did not declare for the disputed land plot, only declared the land plot no. 325, according to the testimony of Mr. D1 and Ms. T2, the land plot number 325 was their land plot, then exchanged for Mr. U and Ms. K, and have been granted a land use right certificate for this land plot, and Ms. T2's household has been granted a land use right certificate for the plot 986A, the disputed plot 986. On the other hand, no one complained after Ms. T2's household was granted the certificate of land use right for the disputed land plot, until 2008, when Mr. U and Ms. K died that the dispute occurred between their children. Therefore, there is a basis to determine that Mr. U and Ms. K exchanged land for Ms. T2, Mr. D1. First instance court supposed that according to map 299 in 1985, Mr. K and Ms. U were the user of disputed land, so the disputed land was the legacy of Mr. U and Mr. U's inheritance has been divided. This is not correct.